a few disclaimers in place. The views that are expressed here in this afternoon are neither the views of, are not necessarily the views of Oxford, of myself, or of anyone associated with Oxford. These are the views of the speakers, and we are hoping for a very controversial debate with many different perspectives on the topic. Nothing is more boring than if everyone just has the same view on a question. And Oxford has collaborated with ETSI on these matters. And we're very happy that we have now also the chance to work on this aspect of standardization, because our main focus so far has been on standard essential patterns and the front commitment, but obviously taking a step back to also understand better the law and economics of standards is an important element. So with that being said, I think it would be helpful if Christian could perhaps offer his perspective and ETSI's take on this matter and what motivated ETSI to launch that event. We're now, by the way, at over 200 participants. Yeah, Christian, I pass on the floor to you. Maybe you could unmute yourself. Thank you.
Well, good afternoon, everybody. And first of all, thank you very much, Raya, for this fantastic work you have been doing in those difficult period and difficult time for you. And I know that it has been difficult, and I really want to thank you for this great work. Having said that, I just want to remind some few things, very simple things, about the situation which has been created by the James Elliott case. I mean, first of all, European standards help shaping the European internal market, of course. I mean, it's in support of European policy and legislations, but it helps also to implement those European policies. So according to the new approach, some of the EU directives lay down essential requirements such as standards, so-called harmonized standards. And the use of those harmonized standards can presume that they meet the essential requirements of respect of the respective directive. That gives a presumption of conformity, which is absolutely a huge benefit for the whole industry, and especially for the SMEs in Europe. However, those European standards and those harmonized standards are produced by private entities and in principle belong to said entities. But anyone can use those harmonized standards, and their use is voluntary, of course. They only become mandatory if they're referred to in contracts, law, or regulation. And the James Elliott case is a landmark decision, as it's the first time that the ECJ had to decide upon the normative value of such harmonized standards. One of the questions was to analyze if those harmonized standards adopted by a private European standard organization is subject to court's jurisdiction to give a preliminary ruling on the interpretation pursuant to Article 267 of the treaty. I will recap that Article 267 states that the Court of Justice of the European Union shall have jurisdiction to give preliminary ruling concerning the interpretation of the treaties, that one thing, but here is the interesting, the validity and the interpretation of acts of the institutions, bodies, officers, or agencies of the Union. So this question has been raised and has been looked at by the European Court of Justice, but it also had created quite some difficulties in the production of those European standards. And for all the stakeholders of standardization, the situation has been more difficult and complex. And we believe in ETSI that some total open debate about this situation is really necessary today, because the dialogue seems to be a little bit difficult around the new approach and how we will in the future produce those standards. So we've been very happy that Oxford could take the lead on that discussion. And I do hope that it will be very open. There is no taboo. There is no restriction to speak. And I hope that this debate will foster more comprehension on all the sides of the stakeholders with respect to this upcoming situation. So I would also thanks very much all the participants, all the members, and I handle the floor to you, Raya, and to the panelists. Thank you very much.
Okay. Well, thank you very much, Christian, for these few words. I think we can now basically move on to our first panel with Sir Nicholas as the chair and Dr. Zielke from the German Ministry of Economy, and Ms. Katrin Dingemann, who has been preparing a testimonial for the ministry.
Well, although notionally chairing this session, well, welcome to everyone. And I see our participants are up to 220. I think my task in chairing this first session is merely to go straight to Dr. Zielke, who will make set the background for why the Redeker opinion was sought, and then we will hear, of course, from lawyer Dingemann the assessment of why, and then I will try and keep some control over the questions that come, which I'm sure will be inspired by the presentation. So without any more, over to you, Dr. Zielke, and can you set the ground as to why the German government in particular sees this as such an interesting, one might even say controversial area?
Well, thank you, sir, Mr. Chairman, and Ms. Gaffel and Mr. Loyal, and all up to other participants and the audience. I am glad to be here, and certainly we know why we have done this, and I will tell you in a minute. So the first thing I'd like to do is to thank ETSI and Oxford for having me at this virtual meeting, which obviously shall help to understand recent developments in standardization policy following the James Elliott decision, and maybe to discuss ways how to exit the turmoil caused by different views from many member states and the EOS on the one hand and the EU Commission on the other hand, about what the decision actually means for the daily work of the EU Committee on Standards and likewise for the ESOs. So these different views already caused a lot of discussion and even significant delays in standardization work, which we cannot afford in times when horizontal topics such as artificial intelligence or digital economy, Green Deal or circular economy and other issues call for a new and rapidly developed harmonized standards on a European level. So all actors have to realize now a view that no matter of discussions about how many HAS consultants have to assess a newly drafted mandate or what the new requirements for publishing a new standard in the EU journal must be, international competitors from China and the US will not wait for us. Thanks to the NLF, Europe has a lot to offer when it comes to standardization, new technologies, but also in terms of transparency, participation, opportunities, or with regard to ethical questions in artificial intelligence, just to name a few. Well, triggered by a significant part of the business community and by the standardization organizations on a national level, but also on the European level, the current German EU Council presidency has decided to take action and has brought the issue forward to the political agenda. To address this issue at hand, we initiated a newly formed Council Working Party on Technical Regulation, which had been in session already twice. in 2 workshops, one focused on the future of the new approach and the state of European standardization, and one on artificial intelligence. This one is to come later on December 14. Well, it turned out then that we need more substantial and constructive dialogue between member states, ESOs and the Commission about what the conclusions of the James Elliott case should be. I'm glad the GD GROW, as well as the GD Connect and Commissioner Breton himself have expressed their readiness for a substantial dialogue to solve the problem. The European Commission underlines that it will participate in the further debate. Possible benchmarks, a consultant assessment, and new ideas for the publication of new standards are worth considering. One reason for the, in our view, problematic changes of procedures imposed by the Commission was the presumption of some EU services that the European Court's ruling in the James Elliott case included a statement that standards are integrated part of the EU law. But the problem is standardization de facto and legally in all member states always was seen as a primarily private business, and even as a model for public-private partnership to be complied with only voluntarily, and as such exactly not being a law. I leave out the cases where legislators as an exemption take reference to specific standards in the law itself here. So that's why a large part of the discussion also was related to the legal question, whether or not it was necessary to introduce these various new control mechanisms and whether this is covered by the Standardization Directive 1025 from 2012. Since then, there have been numerous legal opinions from the ESOs, some NGOs, from Business Federation, and so on and so forth. In particular, in a presentation by ETSI, standards are described as pillars of the digital development and as a basis for digital sovereignty. It is emphasized that standardization takes place on a voluntary basis and that all stakeholders are invited to participate in the process. In this context, references made to the legal study commissioned by Germany and also to the so-called Bild report. Europe, it says, has self-imposed problems in the field of standardization, which result in advantages for other global players, and that's for sure. For this reason, some companies now hesitate to invest time in standardization. The system as a whole works, but it needs to be reformed. I may finish my citation, and I cannot agree more. As the Council presidency, the German government had the intention to revitalize the discussion in order to offer a new foundation for the legal discussion about whether the presumption that standards may be considered as being a law is undoubtful or not, and whether or not there will be alternative legal ways and means to follow both the Standardization Directive and the necessary conclusions from the Elliott ruling at the same time, without building up tremendous or even humongous hurdles when creating and publishing standards. But this requires to involve the legal service of the Commission. As representatives from one member state pointed out, the European Court rules on cases, but is still not the legislator, meaning we altogether have to follow the Standardization Directive and its spirit, which in fact was adopted by the legislator. So we asked a well-known law firm to conduct a legal study, which then in summer was published in 3 languages on legal aspects of the current debate, on the implementation of the EU standardization regulation, on in-depth technical evaluation or of standards drawn up by the European Commission and the US consultants of Ernst & Young, and on new requirements for mandates which have been repeatedly criticized by numerous member states in the EU Committee on Standards. Sorry, our aim was not to convince everyone of a particular legal opinion, but to objectify and structure the various discussions on this issue. We hope that the legal opinion will help you as experts in your discussions. I would like to briefly mention 3 key findings of the legal study before Katrin Dingemann goes into details. The court describes in its James Elliott ruling Harmonized Standards as part of union law. This sentence has been mentioned often ever since. This sentence. But according to the findings of the legal opinion, however, the court did not want to make a call for an increase in the intensity of assessments of harmonized standards by the Commission. It was rather to be interpreted specifically in the context of that court's decision and concerns in particular the question of whether the court has jurisdiction in that specific case. Second, the standardization regulation in fact requires the Commission to examine whether the harmonized standard corresponds with the standardization request and the requirements of the corresponding legislation. However, the lawyers point out that the examination must primarily only refer to formal aspects and the completeness and logical consistency of a standard. They warn that also in the light of the NLF's concept, which is economy-driven, standardization processes must not be duplicated by the Commission. Third and finally, the legal opinion also raises the question of possible liability scenarios for the Commission in the context of harmonized standards. According to this, the Commission's own liability is conceivable in theoretical cases, but always limited to her own actions and not to the actions of private parties such as the ESOs. In conclusion, the lawyers point out that an extension of the assessments could even lead to an extension of potential liability risks for the Commission, and I doubt that there has been a budget for this. The European Commission concedes so far that important discussions points have been made, which describe the current situation after the James Elliott judgment. Both Commissioner Breton and the two Directorates General involved, but not the legal service, have indicated they want to lead a more substantial discussion with member states and ESOs, which was necessary because 20 member states have associated themselves with a joint paper that explicitly calls for this discussion and puts emphasis on solving the recent and in their eyes all too often self-inflicted problems. Even mandates had to be withdrawn from voting or were adopted only with a number of objections and abstaining votes. A work plan is currently being drawn up together with the European standardization organizations, and the European Commission points out successes and improvements in the standardization process since 2018. Account, they tell, had been taken of the wishes of the member states in the Commission's claims. They say 62% of the applications for standardization have been published in the official journal. Only 22% have been rejected, and the remaining applications were still being processed. We acknowledge and greet these attempts. However, they have not led to a substantial solution so far. The European Commission is currently working on a new standardization strategy to reach improvements, and so will we. My hope is also the European standardization organizations and the business community will be constructive and take part in these discussions to come. Well, for the details of our study, I'd like to ask the authors of the study, Katrin Dingemann and Matthias Kottmann, who unfortunately cannot join us today, but Katrin was the person indeed anyway. So you are in best hands. And I would like to ask them to give you a presentation. So we'll be happy to discuss your questions after that, my understanding, and thank you very much for your attention.
Thank you. Thank you very much for the kind introduction, Mr. Zielke. And thank you, Roja and Christian, and also Nicolas for the introduction. I'm very happy to be here. Thank you for having me. And I'm glad to present some of the key findings of the legal opinion Mr. Zielke just mentioned that was commissioned by the German Federal Ministry of Economics and that I've drawn up together with my colleague, Matthias Kottmann. As Mr. Zielke already mentioned, I will focus today on two issues, and maybe to give you some help, it would be very helpful to start the present PowerPoint presentation.
Yes, I think the way Mariolina, can you just open it now from yours, because Mariolina says it works Can you check? You just open it from your computer, as Mariolina says?
No, Roya. What we have done before is that everybody can share their own slide.
Yes.
I don't have access to...
I know, but as Professor Antonio suggested, you can just open from your slides now, your slides, Katrin. From your computer.
As I've been told that you will do it, I'm actually not...
Okay, no, fine, then I'll do it, no problem. Where are you? No problem, I'll do it. I have it up on my screen.
Thank you very much, Roya. I'm sorry.
It's difficult to hear what but how do we share now my screen after she said share screen? Here you go. Share. Does it work?
Perfect. Yeah, it works. At least it worked for me.
Great. Maybe 1 second. If I put it on maximum, how do I do it? Just get started. I'll play around. Well, I think I have it. So, okay, we have it. Perfect. And we can see you. Okay, good. Go ahead. And just please tell me when I should turn the page.
Okay, so maybe now for the first time, please. Thank you. As you can see now, I will focus today on 2 issues. First, on the legal nature of harmonized standards in the light of the James Elliott decision. And second, and I will focus on the extent.
Yes.
Sorry, Roya, could you mute yourself? Because. Thank you. And secondly, I will focus on the extent of the assessment of standards that is carried out by the EU Commission before its decision to publish the reference of a harmonized standards in the official journal. And maybe at the third point, I've put that in gray on my slides. I will conclude with a very, very brief remark about an ongoing proceeding before the General Court that was not part of our legal opinion, but which will probably clarify some of the questions that we are discussing today. Okay, so next slide, please. Thank you. Let me start with a short introduction regarding the James Elliott judgment. You're probably all aware of the contents of the judgment, or at least you all know this one key sentence about harmonized standards being part of EU law, which is probably the most discussed sentence of an ECJ ruling ever by now. However, I would like to briefly explain the context of this sentence, because I think that it's crucial for the understanding, and also because I think that the consequences of the judgment are generally overestimated because the context is not sufficiently taken into consideration. Christian, you've already mentioned that the question, or one of the questions the ECJ had to decide on in James Elliott was whether it had jurisdiction to interpret a harmonized standard in a preliminary ruling procedure. As you know, the court affirmed its jurisdiction, but it did so with a very interesting reasoning that differs from that of the Advocate General. So let's have a short look at Article 267 TFEU. You can see it on the slides. It provides that the court shall have jurisdiction to give preliminary rulings concerning the interpretation of acts of the institution, bodies, office, or agencies of the Union. The Advocate General in the case took the view that harmonized standards indeed are such an act of an institution, body, office, or agency of the Union, and he therefore held that the ECJ had jurisdiction directly on the grounds of the wording of Article 267 TFEU. The ECJ, however, follows a different approach. It referred to prior case law in which it had stated that the ECJ, under certain conditions, may have jurisdiction for the interpretation of an act that is adopted by a body which cannot be qualified as an institution, body, office, or agency of the Union. So the ECJ relied on an extended interpretation of Article 267 beyond its wording. This extended interpretation, according to the ECJ, shall apply for measures that are implementing or applying an act of EU law. And to support its finding that harmonized standards constitute such acts or such measures implementing or applying an act of EU law, the ECJ relied on 3 reasons. Next slide, please. Thank you. Firstly, it referred to the publication of references in the official journal. Second, it referred to the legal effects of harmonized standard, so in particular to the presumption of conformity that was already discussed in the introductions. And it was also in this context, with the presumption of conformity, that the ECJ based its finding on that harmonized standards form part of EU law. And the third reason the court gave was that harmonized standards are strictly governed by the essential requirements of the directive, and that their adoption is initiated, managed, and monitored by the Commission. Next slide, please. Thank you. I consider the judgment to be quite correct with regard to this question of jurisdiction of the ECJ. Obviously, the ECJ wanted to establish its jurisdiction to ensure a uniform interpretation of harmonized standards throughout the Union. And to do so, it was necessary to qualify the harmonized standards as part of EU law, at least within the context of Article 267, because naturally the EU law constitutes the outer limits of the ECJ's jurisdiction. However, it is very important to note that this procedural classification as EU law does not imply that harmonized standards are genuine EU law in a substantive sense. In my opinion, this follows directly from the grounds of the judgment itself. Firstly, even if you take into account the James Elliott judgment, harmonized standards lack practically all the essential criteria for EU law. EU law must, of course, be adopted by an institution or by a body of the EU. It would run contrary to the principle of autonomy of the European Union to accept a source of law that is not the treaties or established in accordance with the treaties. However, as I've just explained, the ECJ itself held in the James Elliott ruling that harmonized standards do not stem from EU institutions or bodies. They cannot be attributed to the Commission. And this was confirmed once again in 2018, I think, in the Zaxa case. Furthermore, EU law must be democratic. This follows from the founding values that are set out in the treaties. Therefore, acts of EU law can only be adopted by bodies that are subject to democratic scrutiny. However, the standardization organizations are not subject to democratic scrutiny. Again, the ECJ confirmed in the James Elliott judgment itself that the European standard organizations are private bodies that are not accountable to the EU legislator or to national parliaments. Also, EU law must be subject to judicial review. The EU is a union that is based on the rule of law, in which no legal effect may be accepted that escapes judicial control. However, harmonized standards as such are not subject to judicial review. They can be interpreted in preliminary ruling procedures, but they cannot be subject of an action for annulment under Article 263 TFEU. Again, this was confirmed by the court in James Elliott, at least implicitly, where it held that such standards are not acts of an EU institution or body. Besides not fulfilling the basic criteria for EU law in a substantive sense, there's, oh no, sorry, just switch back, thank you. There's another reason why standards cannot be regarded as EU law in a substantive sense. And this is that such assumption would be inconsistent with the very nature of the new approach. It is the very basis of the new approach, as you all know, to differentiate between the legal requirements that are set out in the harmonization legislation on the one hand, and the voluntary harmonized standards on the other hand. The whole concept of the new approach is based precisely on the fact that the EU legislator confines itself to defining only the main safety requirements, while the technical specifications are left to non-binding standards that are developed by private standardization organizations. The conclusion of my first point is therefore that the classification of harmonized standards as part of EU law is limited to the specific context of Article 267. It also follows from this that the requirement of genuine EU law do not apply to harmonized standards, such as, for example, the obligation to state reason, or very important, the obligation to publish the full text in the official journal. Next slide, please. I'm sorry. And with this, I will already come to my second main issue, which is the question of the extent of the Commission's assessment of harmonized standards before publishing its reference in the official journal. You've probably noticed, and it has been mentioned, that the Commission has taken the James Elliott ruling as a reason, or as an opportunity maybe, to make certain changes in the standardization process. Some of these changes are of a mere procedural nature. For example, the Commission now publishes the references of standards in the form of an implementing decision in the L series of the official journal and no longer in the C series. But what is more important are the substantive changes with regard to the assessment of harmonized standards before publishing the reference in the official journal. These changes have already, Mr. Zielke mentioned it, caused a lot of delay and a lot of problems during the last months. In a communication from the Commission on harmonized standards of November 2018, the Commission announced to follow the development of standards more closely and more thoroughly, and to review even the technical aspects of the standards and the procedure of its drafting. And since mid-2018, I think, the Commission is using the assistance of the HAS consultants for this assessment. In my opinion, and this is one of the key findings of the legal opinion, there is no legal basis for this extended assessment of harmonized standards. It is certainly not the James Elliott judgment itself. The judgment does not impose any new requirements on the Commission's assessment. In fact, it does not contain any substantive requirements regarding the Commission's involvement in the standardization process. The ECJ merely factually describes the Commission's influence without linking it to normative requirements. Next slide, please. Therefore, the requirements for the Commission's assessment continue to derive solely from the legal framework, which is in this case the Standardization Regulation 1025/2012. In particular, this is Article 10, Section 5 and Section 6. These provisions indeed require the Commission to verify that the standard that was prepared by a European standardization organization is in compliance with the underlying standardization request and in compliance with the essential requirements of the respective harmonization legislation. However, the level of detail and the depth of this assessment cannot be directly inferred from the wording of the regulation and must therefore be determined by interpretation. Next slide, please. Thanks. Such interpretation of the standardization regulation shows that the EU legislator wanted to limit the Commission to a largely formal role at this stage. At this stage means before publishing the reference in the official journal. If you have a look at the Commission's participation in the standardization process that is set out in the standardization regulation, you will notice that the regulation foresees different kinds of procedures. At the stage of the adoption of the standardization request, so at an earlier stage, the regulation provides for the involvement of the Standards Committee in a comitology procedure. The Standards Committee, consists of representatives of the member states. And also at a later stage, when there are formal objections under Article 11 that the Commission has to decide on, there's also an involvement of the member states because this standardization committee is involved in the process. It follows that the EU legislator wanted to provide for an involvement of the member states at all stages in the process when the decisive course for the conformity of the standard with the harmonization legislation is set. However, the decision on the publication of the reference of a standard in the official journal does not provide for an involvement of the Standards Committee, and so does not provide for an involvement of the member states. This systematic reason alone shows that the role of the Commission is much more limited at this stage. The systematic interpretation is confirmed by the telos, so by the meaning and purpose of the standardization regulation. Under the new approach, it is the European standardization organizations and not the EU institutions that are responsible for specifying the legal requirements by means of technical specifications. This deliberate choice of the EU legislator has been confirmed once again in the run-up of the adoption of the standardization regulation in 2012, because in an impact assessment, the alternative of a European standardization agency was explicitly rejected because it was too costly and because the institutions were lacking the sufficient technical expertise. Next slide, please. It follows from the interpretation of the standardization regulation that the Commission's assessment under Article 10, Section 5 and 6 of the standardization regulation is limited to a largely formal comparison of the harmonized standards and the underlying standardization request. This means that the Commission essentially has to check the completeness and the logical consistency of the standard, but that it may not carry out a fundamental and full review even of the technical contents of the standard. In particular, it may not duplicate the standardization process and substitute its own assessment or that of its consultants for the content agreed upon by the standardization organizations or the respective technical committees. What is interesting is that until recently, the Commission itself took this view. The Blue Guide, which is only from 2016, explicitly states that no assessment of the technical content of standards is required during the review because the Commission does not take responsibility for the technical content. Next slide, please. Due to the deliberate system choice of the EU legislator that I've just described, a detailed assessment of the technical content of standards and also of the standardization process and its inclusiveness cannot be foreseen in Commission working documents, because this would be in contradiction with the system of the legal framework, would be in contradiction with the standardization regulation. In summary, we can therefore state that the James Elliott ruling changed practically nothing except for the ECJ's jurisdiction to give preliminary rulings on harmonized standards. The judgment cannot therefore serve as a basis for fundamentally reshaping the standardization process. Next slide, please. So maybe just as a very brief comment as my third and my last issue, I would like to briefly draw your attention to an ongoing procedure before the General Court, which you are probably already aware of, and which may soon clarify some of the issues that we are discussing today. In this case, so case T185/19, the applicants request access to 4 harmonized standards under the Access to Documents regulation. And the Commission refused to grant that access, relying on Article 4, Section 2, first indent of the regulation, which provides for an exception to the access right to protect commercial interests and intellectual property rights. And the applicants are now contesting this decision of the Commission, so this denial of access to grant access. And they are, of course, relying to the James Elliott decision. Namely, they argue that harmonized standards are part of EU law and must therefore be accessible, freely accessible to everybody without paying a fee, and there cannot be a copyright in harmonized standards because they're part of EU law. I'm representing 10 and 15 national standardization bodies as interveners in this proceedings. And we've had a very long and very intense hearing in this case on November 10th. It became clear that the General Court, well, at least intends to deal with the issues in a very fundamental way, because they were asking questions about criteria for EU law and whether there's a general principle of publicity of the law. So I can therefore conclude that there's at least the prospect that some of the issues that we are discussing today and that we are discussing for many months now will probably be clarified in the foreseeable future in 2021. Thank you very much for your attention, and I look forward to answer your questions.
Our next panel is the Law and Economics panel, of which I personally am very excited about, because I think it's really, really instrumental to think about both aspects of obviously the substantial legal questions which we have developed and discussed at length in the previous session, but also to look at the economic impact and the economic consequences of judicial decisions. The institutionalization through law of certain economic behavior is an exceptionally exciting area, which I personally find very exciting and interesting. And we have a great panel. We have Professor Kay Purnhagen from the University of Bayreuth and Professor Henk de Vries from Erasmus University Rotterdam, who will both make an intervention and hopefully give exciting, interesting talks. Kay, since I see you and I don't see at the moment Henk. Oh no, I see you both. So who wants to get started first?
Henk, you first.
Shall I start?
First the economic practice and then the lawyers.
Okay.
And Henk, do you want me to share your screen now that to share your presentation, or do you want to do it now that I've understood how to do it?
You can share the presentation.
Okay.
Next, if it's the next one.
1 second, where are we? Here you go, Henk. Okay, can you see my screen?
Not yet.
Not yet. Well, how do I share screen on this whole thing?
Otherwise, I can do it.
I have it. I have it. You got it.
Yes.
So just please tell me when I should turn to the next slide.
Great. Thank you very much. Good afternoon, everybody. It's a pleasure for me to share some ideas. I'm not a legal expert. I'm by education an engineer working at a business school and specialized in the field of standardization, even standardization management. We've had a short break and we saw a piece of art, culture. And I think this is at the end what we want to achieve in Europe. We want to have well-being and good life. And of course, we need industry to support this. We need welfare and well-being both. If we would have an ideal world, then industry would take its own responsibility to provide us with good life and to care for consumers and for workers. Unfortunately, this is not always the case. So we really need legislation as well to give requirements for European business, also to give requirements for foreign companies that want to export to our market. In order to do that, today we are talking about a new approach, but it's good to remember that we had an old approach. The idea was there are differences between member states, own rules for, in particular, safety. The idea was to have one single market without barriers to trade, and that included harmonization of legislation in the form of European legislation. Then you needed a compromise between countries. This was really time consuming. And at the end, there was legislation, but sometimes it was already out of date at the moment it appeared. That really hindered innovation. So then there was the brilliant idea to have a new approach with only essential requirements in legislation and the details in standards prepared by industry for industry. This put the responsibility where it should be, at the side of industry. It led to more speed and to more quality. Next one. Next slide.
No. Here we go.
So we saw solutions that provide a balance between safety and business needs for the benefit of industry, but also for the benefit of workers and consumers to provide them with safety. It supported EU policies and policies by national government, and it was informative and is informative for inspection authorities at the national level. So far, so good. Even I would argue we have a better system in doing it this way than our friends in China and the US have. They have more rigid systems. So in the US side, it's at the cost of business, and if they do not have better safety. And in China, they violate their own rules, and in that way they can support business, but at the cost of safety. So our system is definitely better. Next slide. But we have the James Elliott decision. No, back to the previous one. Yes. Which makes standardization part of the legislative system. And of course, this maybe it's understandable that this decision was taken, but it's clearly not in line with the main idea of the new approach. And then we had to follow up with other court cases with European policy consequences. So once there is a court decision, this is seen as the new truth. And we also see this in the scientific community, in the law field, that my colleagues at universities in the field of law take a decision by court as the new truth and then build on that. Next slide. And this leads to problems. First, problems for industry, making standardization less attractive. There are delays. There is a risk that a reference to a standard will not be included in the official journal. In that case, it's really frustrating to the participants in standardization. And we also see some extra requirements to the standardization process. In the worst case, if industry is no longer willing to do this, then we will go back to the old approach. There's also apparently a problem at the side of the European Commission, because they more often take the decision not to immediately accept standard or not at all. So there are delays. Apparently they're not satisfied either. So what we can see is a juridification in the sense of expansion of juridical power, symbolized by the change in the reference from the L series of the official journal to from the C series to the L series. And this may affect the main purpose, the single market without barriers to trade. It may affect, at the end of the day, safety. It may be at the cost of European values, in which trust is essential. And what is happening now is affecting trust. So the question is how to escape from this situation. Next slide. I guess that most of you have seen the 9 dots problem. 9 dots arranged in a set of 3 rows. And then the challenge is to draft 4 straight lines which go through the middle of all of the dots without taking the pencil off the paper. I guess you have tried this exercise. Let's move to the next slide. There you see the solution. And typically, in order to get a solution, you have to think out of the box. You have to get a wider perspective. Well, then applied to the issue of today, we need more than just a legal perspective. And that raises the question, which other perspectives do apply? Next slide. The session was announced as an economic perspective, and indeed this makes sense because standardization is an economic activity. It's an activity within the business world, and the business world is characterized by the economic aspects. This listing of 15 aspects comes from the Dutch philosopher Doyeweert. And when we are talking about the new approach, that's not only about the economic aspect, but it includes the ethical side. So safety is an element of the ethical aspect, and this gives direction to the economic aspect. So business is more than just for profit. It also is about addressing societal needs. That's included, if taken in a broader sense, in the economic aspect. But other aspects do apply as well. First, the fiscal aspects, and that relates to the content of the standard. Most standards are about technology. A second aspect that is important is the logical aspect. In the case of safety, a risk assessment is needed as a basis for a standard. Then the historical aspect relates to creation and to decision making. The linguistic aspect relates to language, and that should be clear. And here it helps to have a German and a French translation, because those languages are more precise than the English ones. So you get a better text. The social aspect relates to the committee, agreement between people who cooperate. And then just one in the list is the legal aspect, the juridical aspect, that you may argue it has to do with legislation, but in the first place, a standard is an agreement between parties that can be used in a contract. You may refer to a standard between parties. And indeed, it also can be used in legislation, and then the legislator refers to a standard. The final one, the faith aspect, has to do with the ability to believe. So that has to do with trust. And this is really important in the other parts of the world, both in China and in the US, we see less trust. And in the European tradition, we have more trust, and this is being affected now. We move to the next slide. By tradition, standardization is seen as a technical activity. By engineers, there's a technical solution. It's about technology. The standards bodies have technical committees. And the question is then, the standard, is this a technical good solution or maybe not? Or standardization a business activity? Then we have the business paradigm. That's about business people, about business solutions. It's about money. It's about technical diplomacy. What we can see is that indeed there are interests as well. So developing a standard also to meet the essential requirements can be more than just a technical issue. There are experts, but they also may represent interests and may write a standard in such a way even that it might deviate from the essential requirements for the sake of business interests. Then it's not only about business and technical, it's also about safety, or it may be about other societal issues. And then I would talk about inclusive business that is really more than just about money. Then we would like to see multiple stakeholders, including not only producers, but also users and societal stakeholders. It's about responsible business, has to do with values, and the standard can be a value-based design. Well, value-based design, so it might be about not only about safety, it might be about each of the Sustainable Development Goals of the United Nations. All of them are candidates for a new area of standardization in order to make sure that business does a proper job and that it meets public interests. Next slide. Standardization has a certain process. Here you see the main stages. There is first standards making and then standards taking. Typically in the new approach, the EU plays a role at two stages of this process. At the start, there's a standardization request. So it's not only standards, or the set of standards is not only developed because of the interest of industry, but also answering the request by the EU. And then at a later stage, before market acceptance, there's the acceptance by the European Commission of the standard. Do they accept it for inclusion, for reference in the official journal? Next slide. This raises another question. How is the relation between the European Commission and the European standards bodies? Is this a question of hierarchy, or are they next to each other? There's a regulation on standardization, and this regulation, so the fact that there is legislation as such is an issue of hierarchy. In my country, the Netherlands, we have managed almost 100 years without any legislation on standardization. It was just a private activity introduced by engineers and industrialists together. And the government was just one of the stakeholders next to the national standards body. In the EU, this is partly different because of the legislation, but because of more than that, because this legislation as such provides requirements for the national standard, for the European standards bodies and for the system and how it works. Nevertheless, the European Commission, when I asked this to them, they see themselves as next to the European standards bodies. And maybe for that reason, they changed the word mandate, that seems to refer to hierarchy, with the word standardization request. That's a question, and the answer can be yes, but it also can be no. And if yes, then the standard is being developed, and then after development, it gets accepted or not. Next slide. So here we see this process with in orange the role of the EU, the standardization request at the beginning of the process, and then a decision whether or not to take that standard, and that is a form of output control. In terms of quality management, this is a rather primitive way. It would qualify as the second generation of quality management. The standardization process as such has a form of quality management. So the ESOs all have an ISO 9000 system, so they have a form of process control within the committees, but at the end, the European Commission has a final decision whether or not to take the standard. Next slide. From a quality management perspective, this entire process could be upgraded to the fifth, for instance, the fifth generation of quality management. Then there would be more emphasis on the professionality of the standardizers. There would be more business orientation and more attention for social values. A common vision between the standardizers and the European Commission on the basis of trust. And then you need more system orientation, more business process management. There should be a European strategy, both at the political side and at the industry side. And typically you would address multiple aspects and multiple stakeholders would be involved. Next. If we do it that way, then here you see a kind of to-do list for the EU, and I will not go into all details of this list, but I would propose to revise and reduce legislation. I think the current texts are too detailed and sometimes misunderstand the role of the EU, put it too much in the role of hierarchy instead of next to the standardization bodies. The new approach directives could have a reshape in the sense of only essential requirements, nothing more. The new approach as such could be used for other areas as well, as mentioned, for each of the elements of the Sustainable Development Goals. We also can see missed opportunities like the field of data protection. Trade agreements are dangerous. In the CETA agreement, I think it's mainly now at the conformity assessment side that is still acceptable with mutual recognition, that can be good. But it also intends to have more regulatory cooperation, and because our system is better, any compromise makes it worse. With advantage, at least there was one advantage of the Trump administration, that we did not get TTIP. That would have really violated our system. Now with the new American president, we can fear from an American attack on our superior system. The EU should align better with the ESOs, really common preparation, also no deadlines for the process, and the EU itself could participate in the process. And if they presume a due process, then there can be an immediate reference in the official journal, but they still should keep the option to reject standards, to keep to maintain the clear separate responsibilities of the legal system and the standardization system. There could be dynamic references. This was mentioned already by one of you, and the transition periods to allow industry to prepare for changes. Next. There's also something to do for the ESOs at 2 stages, not only during standards development, but also in the pre-normative stage. It would be good if they are even more proactive than they already are. So to explore new fields, relate that to policy areas, cooperate with also with scientific researchers, see where standards as such are enough or where a kind of new approach would be needed. And they also may pre-draft standardization requests to the EU. So really take the lead and not wait for the EU. Next. So as mentioned, the quality management approach might be upgraded. Part of that is to have better education for, in particular, the secretaries, because these are own people, by the national standards bodies or by the ESOs, but also conveners. Careful selection is needed so that they are able to do a really professional job. You cannot expect that from the participants. So these 2 categories of people should be really professionals. There are more stakeholders and stakes, and it should be clear from the outset how to involve these. Next. And to order to do that, you need at the beginning a functional design of the set of standards and then the real standards writing. So also those stakeholders who lack the technical expertise for the details of a standard, they may be involved at the moment of the functional design. And then there are different areas of expertise that should be included. These relate to the different aspects. So not only technical, there are the legitimate business expertise, but also the user involvement. At the moment, it's mainly producers. Really, users should be involved. Linguistic expertise, also the legal expertise, including the alignment with the essential requirements, so that that's part of the process to do that and to ensure that it is fully in line. And last but not least, the ethical aspects for the societal issue to be addressed. Transparency is needed and openness about the choices made, also in the form of a why document. Next. So if you would like to read a bit more, this is what you can see. To conclude, I think it's time to invent the new approach, not to get stuck into legal issues, but to go back to the roots and to make it even better for a good future. Thank you very much.
Thank you. You have published so much on this matter. That's really impressive. Kay, do you want to take it from there?
I can do. I mean, I got the right starting point by not diving too much into legal issues. Thank you. It was a nice bridge that you presented to me. But however, as long as we have what we have, then we have to unfortunately look into the legal issues. And I'm just waiting for Roya to open
your
up
presentations to come.
Yes.
Bear with me.
Still,
I'm spotlighting people around here as we go.
That's no worries. I can already start saying something. I mean, some maybe helpful caveats at the beginning, and that's very important also to emphasize what Dr. Zielke has already said. We talk about harmonized standards here. We're not talking about any kind of standards, and of course, it is free to anyone to devolve standards and implement them into a contract. So this is no problem. And the judgment, of course, will have no effect on that whatsoever, at least not in the current stage. We're only talking here about the specific harmonized standards at the European Union level. And this is, of course, the first caveat one has to take into account. So while the slides are up, I can start presenting my legal view.
They're up. Do you see it?
I can see the slides, okay. And I hope everyone else can.
Great, thank you, Björn.
So thank you so much also for the invite, and thanks also for giving the possibility to speak in front of such a distinguished audience. Can I have the next slide, please? So my perspective is on a legal view, and I'm also trying to, take the audience up where they probably come from. Namely, that is from the area of private law. And if you look at it from standards from the area of private law, and this is basically what businesses and users of standards see, then it is simply a standard, namely a standard which is legally valid by the inclusion into a contract. So whether it's a harmonized standard or any kind of other standard, or where it's come from, who's the initiating body, first and foremost from the perspective of the contract, doesn't matter much. And also, regardless of whether it's a harmonized standard or any other kind of standard, business can choose also otherwise. And therefore, of course, they are voluntary and they will remain voluntary. No one takes that away. But the problem is, of course, the choice not to choose a harmonized standard is a bit more difficult than the choice of not using a non-harmonized standard. Because if you choose to use a non-harmonized standard over a harmonized standard, you may lose a benefit, the benefit of the switch in the burden of proof, which is given to the contracts by EU law, and also it loses the boilerplate nature and the easy market access that is both granted by EU law. So yes, it's voluntary, but of course the EU law makes it a bit harder to choose for other kind of standards, and that is particularly what is also so attractive about harmonized standards from the perspective of harmonization in the European Union at the European Union level. And in private law, however, it's not only the contract is not always what is only everything that matters, but it also can have an impact, for example, in torts, because standards, regardless of whether they're harmonized or not, can have an effect of duty of care regulations, for example, in torts. However, of course, here the switch in the burden of proof is, of course, also very attractive in that respect. So this is the private law view, I think, that everyone basically shares. Can I have the next slide, please? Now, if we look at a bit of the history of how the standards came into being, the harmonized standards came into being, and if you look at it from the EU law perspective, and that has been rightly pointed out before also, that it was basically a reaction to the ill-suitedness of other forms of harmonization in the market. I mean, imagine you would have to come up with technical regulations through directives and regulations all the time, going through whole the cumbersome legislative procedure. This was just not wanted. This was just not what worked at the European Union level. And therefore, as a replacement of the regular harmonization method, the new approach came into being. So from the EU law perspective, it is one aspect of harmonization to realize the free movement of goods in the European Union level. This is first and foremost a view which has nothing to do with any kind of contracts or bindingness. This is just a point of, it's more, it is a better way of realizing harmonization in the area of free movement of goods. It is one of many harmonization methods to ensure market access to other markets. And this is also important that we take into account the market access character of these new harmonized standards. Next slide, please. When evaluating the question of how such market access is actually being granted, then basically EU law has chosen two very competent norms, competent forms of making market access more attractive. One is it provides a presumption of conformity, which is a switch of the burden of proof, basically. This is granted by EU law. And the boilerplate nature of those standards. That means member states can deviate, if at all, from these harmonized standards only under EU law circumstances. So the EU law provides specific rules and regulations when and how member states might deviate from harmonized standards. Those two aspects have nothing to do with contract law. Those two aspects are something which is regulated at the European Union level. Both effects, EU law makes subject to Commission approval and publication in the journal. So both effects, the presumption of conformity and boilerplate nature, are dependent on the Commission approval and on publication. Can I have the next slide, please? So essentially, from the EU legal perspective, it's a free movement issue. It's about Article 34 of the Treaty on Functioning of the European Union. Which means, and it's also important to understand what we're actually looking at when we talk about scrutiny at the European Union level. And the scrutiny at the European Union level is determined by whether there are respective measures. And if there's measures in place at the European Union level, then something is within the scrutiny of EU law. Now, there's arguably 4 measures that can be subject to scrutiny at the European Union level. It's not the standard itself, and therefore everything that has been said so far rightly said, the standard itself should not be subject as such under scrutiny. But the measures itself can be the inclusion into the contract, as soon as contracts themselves can be subject to Article 34, which is debatable. The boilerplate nature itself can be subject to, is a measure which can be subject to scrutiny, the presumption of conformity, because those are the public legal effects, and the Commission approval itself, because the Commission approval by itself is also a public law act. There's nothing to do with standards. Those are all regularly, the letter 3 at least, letter public legal acts, also having nothing to do with the contract itself and the private standard in itself. Next slide, please. So once we have realized that those are more or less conventional measures which are subject to scrutiny, it's subject to debate whether within the standards themselves there can be other types of measures which may be subject to scrutiny. So some say that standards, particularly if you're harmonized, are de facto binding to the market. And if they're de facto binding, they should themselves be subject to judicial scrutiny. Now, this has so far not been said by any court. It was one court case where they have discussed this issue at the European Union level, but the court had said in that case, there's not much evidence that there's actually a de facto bindingness of these standards. And the second, which is being discussed in literature, is that they grant easier market access than other kind of standards, and that by itself should also be a measure which can be subject to scrutiny. And therefore, but this is also subject to debate. This is far from being established, and the court never had said this. Thanks so much. Next slide, please. So, in order to assess now the Elliot decision, which we're more or less coming towards to, and having now established that it's basically about market access, all the new approach regulations, there has to be a necessary distinction between at the border regulation, which concerns market access, and behind the border regulation, which is the national circulation of the product. And this is an old story of trade law. So the rules and the respective types of control, they are different. Some trade law, usually they're more strict when it comes to market access. So when is basically a nation protective against their own businesses? But they're less strict behind the border regulations. So the actual health and safety regulations once the product is in the market. So this distinction is crucial if we look into what can a standard do, how does judicial scrutiny actually work. Can I have the next slide, please? Now, and as you all know, Elliot didn't come out of the blue. There have been other judgments before that had particularly looked into these respective questions, legal questions that I have just highlighted. Now, one of the very first and very few judgments has been the so-called EMC development AB. This was a case under competition law. And the outcome there was a question whether under competition law standards can be subject to review themselves like under the areas of competition law. And there the court of first instance at that time had said that standards cannot be tested for compliance against the validity of the standard in light of fundamental legal principles, simply because the competition rules or are only there to look into the respective commission decision. And if the commission decision in itself is tied to a respective case, it's not the question of whether the standard itself is subject to legal principles, but it's the question whether decision, the exercise of the commission decision is subject to judicial review. Interestingly, in this case, the court had incidenter looked into several other areas, because if a commission decision decides on the validity of a standard, a harmonized standard, the commission has to exercise some sort of scrutiny. And the question then had been, what kind of scrutiny would the commission, what could the commission do? What does it have to do? It's a bit of a similar question that we're actually facing with the aftermath of Elliot. But here the court has been very clear in saying there's not enough evidence on each of these actions that makes standards subject to judicial scrutiny. Can we have the next slide, please? And there had been a next case, the AGM Cosmet case, where basically a question was where a car lift had given way and the car had collapsed and nearly hurt one of the people looking into the cars. And here was the question: what actually happens if everything has been compliant with standard? So the car lift was totally in compliant with the harmonized standard, but it actually was not safe because it had given way. So who is the one actually to test and to also look into whether the standards are actually true, and who has the obligation to also highlight if these kind of standards are not actually safe? And here the court had clearly said, well, if there's such a behind the border regulation, so the compliance with the standards have been met, but then in the actual application, the standards have actually shown to not be safe, this is a matter of member state regulation. So member states need then to notify the commission, and then the commission can take action. And that is in line with all kind of harmonization measures of Article 114, regardless if they're private standards or any kind of other legal act. So behind the border regulations, such as any kind of legal acts, are part of member state regulation. Can I have the next slide, please? We then had the Frabo decision. And this was a very interesting question, because there also a national standardization body had denied market access to a firm which didn't comply with the harmonized standard, but they could prove that by other means than non-compliance, they could get to the same level of safety. And there the court said, well, if it's about market access, so if someone, if a standard has basically is exclusively applied to the at the national level and does not grant market access, then this is something that we have to look into under Article 34, which is the free movement of goods. So here again, you can see if it's something happens behind the border, that is a question of member state. But as soon as market access, entering the good into the market, is at stake, then the court will review. Next slide, please. And this is also then, for me at least, a logical continuation in the Elliot judgment. Because of course, if the court would like to review market access, then they have to be under the scrutiny of the court as well as being acts at the procedural level. Because if you don't come beyond the terminology of acts, they cannot actually exercise the duty that they gave themselves under the former Frabo decision. And therefore, it is of course they have to be subject to EU law if they are indeed if it concerns a market access problem. And therefore, the question whether they are acts in the sense of procedural law have to be yes. This was also, to my extent, no surprise. So yes, because they are framed with all these public legal effects, the court can have a look at this. Now the question is then at substantive level, what is the scope of the review? And there I think we can also look into the previous cases, which is Elliot and Frabo and AGM Cosmet. And if market access is jeopardized, then the court will review. And if it's not market access, so it's behind the border regulations concerning health and safety mechanisms, then it's not going to be under the review of the Court of Justice in the European Union, or that then is determined by member state legislation. However, of course, there can also be a different view. This is now, we've been only looking at the acts, at the judgments, at the standards themselves. Now imagine the Commission by itself establishes, as it did in the recent Commission opinion, establishes more than it actually can. So it does more. It does indeed test more. It also tests for technical specificities and so forth. And that means what then is under review of the court is not the standard, but the Commission decision to exercise these kind of duties. And of course, this Commission decision in itself would also be subject to review. And then the next question is, can actually the Commission also exercise its discretion in a way that it exercises these kind of technical reviews? Now, this is a question that remains open at the moment and can be subject to debate. Can we have the next slide, please? And indeed, look at it from this perspective. Does the CJEU have jurisdiction over voluntary harmonized standards? Yes, it does. And there's no question about this. But the standard, the scope of review is unclear. If you look at the previous case law, it only can look at market access problems. So if actually the standards jeopardize market access. But whether the standards themselves are safe or not, this is something that the court doesn't have jurisdiction, but it has been referred to member state legislation to look into this. A difference might apply if the jurisdiction doesn't cover the harmonized standard themselves, but if the Commission has decided to look into harmonized standard, then the subject of review is not the standard, but the Commission decision. And there it could happen that the court establishes also jurisdiction over the content of standards. Whether this will then open, would be implementing a test through the back door and therefore jeopardize member states' right to assess the standard, the safety for the standards by themselves, that remains to be seen. Can I have the next slide, please? Who should offer an interpretation? One back, please. Who should offer an interpretation of the CJEU decision? Well, anyone is free to interpret everything that a CJEU desires. But first and foremost, the decision, of course, has to be complied with. But if you don't know, everyone has an opinion, can have an opinion on this. But one thing needs to be clear. Addressees need to make certain that they're not blinded by authority. So if the Commission opens up a certain interpretation, it doesn't mean that this is the law. But it means that the discretion of the Commission will be exercised accordingly. And that can turn to law. And then the exercise of the discretion of the Commission can be subject to CJEU review. Next slide, please. To what extent can harmonized standards take legal effects? Well, in private law, it's basically contract and torts. In free movement law, it's market access and market closure effects endorsed by EU provisions, such as boilerplate and so forth. There was two missing links, which I haven't covered yet in the presentation. So the next question which is left open is the question of IP law, which has also already been touched upon. There's just one question, one caveat that I would like to highlight here. We have several other issues where IP laws and other terms of legislation or where certain standards are protected by IP laws, but are nonetheless made subject to EU law. For example, the Nutri-Score in food, we have exactly the same situation. So if now all of a sudden that would jeopardize IP laws, and that would be the outcome of the judgment to come, that would have an effect on a lot of other areas as well. And I doubt that this is actually going to happen, but we'll see. Next problem is competition law. And what is there actually being developed is particularly the question of a patent ambush. That would mean if standardization would hide their IP laws, and then all of a sudden, once a market has become a standard has been dominant, all of a sudden exercise their IP laws. Then this would become an issue of competition law. But at the moment, most of the IP laws are not being really exercised by most of the standardization organizations. And as long as this is not going to be the happen, so if only the two conditions are met, the standard actually rules the market, and second, the IP laws being exercised, then that can become a problem under so-called patent ambush problems under EU competition law. Thank you so much.
In this session, we've tried to analyze 3 following on questions, which we're going to take in turn. And I think we're starting off with Megi Mariachvili, if I remember right.
Good try, thank you.
It's Mariashvili.
Yes, right,
Thank
wonderful.
I'm not the only one with this.
Megi, why did you kick off then and deal with the first question?
Yes, thank you very much. Good afternoon, everybody. And I would like to thank organizers and participants for very interesting discussions we've been having throughout this afternoon. And so, yes, I'm not a conventional presenter in a sense that I have not prepared the PowerPoint presentation. I will try to answer the question directly. So as we divide it in our panel, I will be speaking with respect to the first question. And I think the first question is twofold, and it interlinks 2 important issues, which is the delegation of powers when we look at the use of standard setting organizations and standards in the EU law for the harmonization perspective, and then the hierarchy of harmonized standards in the context of European secondary law with respect to Articles 290 and 291 TFU. So I will start with the delegation. Well, the delegation perspective is not a new one, and it's quite common when you look at the EU constitutional or administrative scholarship. From the inception of the new approach, most of the scholars try to analyze it through the delegation lenses, so to say. And they saw cooperation between the EU institutions and the standard setting organizations as an outcome of delegation of rulemaking powers to standard setting organizations. And this was also address how we view this cooperation in the previous panel. Is it horizontal, or are we talking about the vertical cooperation between EU institutions and standard setting organizations? And usual or common argument in constitutional scholarship, what you see is that this kind of cooperation kind of falls short of old and gold Meroni doctrine, which stated that delegation of discretionary powers to private organizations is not allowed. My personal perspective here is that we should not analyze the cooperation between Commission or EU institutions and standard setting organizations with respect to the delegation perspective and use old Meroni case. I believe that old Meroni case is not already applicable current law, and we should see the evolving court's case law, whether it is applicable or not, and especially the ESMA case recently delivered, which relaxed, to my mind, or mellowed the criteria of delegation. And also this whole cooperation and new approach between which brings together public and private parties should be probably viewed under the context of new governance, using private rulemaking or private bodies for the implementation of EU law. And we've seen the policy papers prepared about better lawmaking, better regulation, where the Commission, even European Parliament and Council promote more involvement of private expert-based institutions in the implementation of EU law. But what does this mean? Then what is the legal ground to ask private organizations to produce rules, which is then published via reference of the Commission in the official journal, and given the effect then to these private rules? One is clear, and if we take the Articles 290 and 291, which delineate the delegation framework, so to say, within the EU, they speak about interinstitutional delegation. So if we look at the treaties, we don't find explicit articles which allows EU institutions to delegate their powers, not only to private institutions, even to the agencies. And then the question comes, what we have these articles 290 and 291, is this the closed system of delegation? Is it that we only recognize interinstitutional delegation, or it is possible to delegate EU powers to the agencies and even to private bodies such as standard setting organizations? And one caveat here, I'm not trying to equate private bodies and agencies here. I am aware of the distinction that standard setting organizations are not the EU agencies. Already mentioned ESMA case, the court was facing the similar question, but with respect to the EU agency, European Securities Market Authority, and the court said that although it is an agency and the powers are delegated to the agency, the current articles 290 and 291 does not provide the closed system of delegation. And the court looked to the whole EU treaties and said, since we have Article 267, 263, which speak about one of the interpretation and second of the annulment of the acts of EU agencies, this means that delegation of the powers to the agencies are implicitly allowed within the treaties, although not explicitly stated in the articles. But this is not the case for the private standard setting organizations. And then on what grounds the Commission goes and asks? We've been speaking about the mandate, or rather request, as the regulation calls it, not the mandate. On what basis the Commission adopts the mandate? Is this more like an act under 290 TFU or 291? By looking at the wording of these two articles, to me it is clear that when we are talking about standards, or even the mandate on which basis the standards are then produced, it's not an Article 290, which is providing or amending and providing further details to the non-essential parts of the legislation. But what Commission aims to do is to provide uniform conditions for the implementation of the harmonized regulations within the member states. So for this perspective, the Commission goes and asks standard setting organization to produce these technical rules. And the Commission's mandate, to my mind, resembles to 291 TFU Act, so implementing measure. And if it is so, and then we see even in the regulation, the mandate follows the comitology procedure, unlike when the Commission references the standard to the harmonized, in the official journal. So mandate itself is an implementing measure if we follow this kind of a chain between delegating powers, first from the EU legislator to the Commission to provide uniform conditions for the implementation, and then Commission sub-delegates, one can call, to the standard setting organizations to provide detailed rules in order to implement the EU legislation in a harmonious way in all member states. And going back, what I wanted to mention as well about delegation debate is that court was quite cautious. Court could have, in the James Elliott case, court could have taken the delegation view and opened up the Pandora's box of then following question, was it a lawful delegation or not? Court did not take this tricky path, so to say, and did not argue that this was a case of delegation and that's why harmonized standards fall under the scope of EU law, unlike the AG. AG mentioned that this case presented the case of controlled legislative delegation to the standard setting organizations. And this wording is very interesting as well. Although AG used the delegation view, it still put it controlled to avoid the further objections, whether it was lawful delegation or not. It called it already controlled delegation. And for me then, the acts produced by the private parties, private organizations, that is standard setting organizations, on the basis of the EU implementing act, as such, are not EU acts, EU secondary acts under Article 290 and 291. By their content, they resemble 291 because they are the ones which establish the uniform conditions for the implementations of the EU Act. So they are kind of atypical, I would say, implementing acts. But what happens then, and that is the core of our discussions, that what kind of review and control Commission should do to the already produced standards, which are produced on the basis of the mandate under Article 10 of the regulation. And Commission adopts a decision by which it publishes the reference to the in the official journal to this standard. And Commission's decision, to my mind, to publish the standard can be qualified as an implementing act, meaning that it can be subject to the annulment action under Article 263, but not the harmonized standard itself. What it means then, the interested parties can annul Commission's decision to grant the legal effects to the harmonized standard. And this, of course, can cause indirectly review of harmonized standards if it was the court deciding it, but not itself the harmonized standard. And I won't go into detail because I know my speakers after me are talking about this more. So in conclusion, I would suggest that stricto sensu, I would not label the cooperation between Commission or EU institutions and standard setting organizations as a case of delegation. One could still, to maintain the link to the EU articles or treaties, can see it as a case of sub-delegation, and harmonized standards by its content can be seen kind of an atypical implementing acts, but formally they would not follow to be considered implementing acts under Article 291. Thank you.
Thank you, Meggy. Now, Marialina Aliantonio, you're going to follow on then. Are you dealing with the second question, I hope? Marialina?
Yes, here I am. Sorry, I'm
yes.
Yes, I guess everybody hears me and also everybody sees my slides. So good afternoon, everyone. Thank you very much, Roya and Christian, for inviting me. My name is Mariolina Liantonio. I am a professor of European and Comparative Administrative Law at Maastricht University and one of the few standardization nerds, and well, very many convened in this meeting today, but very few in the realm of sort of EU law. But so what I would like to talk about today, and also to follow up a little bit on what Meggy has discussed, is to focus on the issue of control of the Commission over the harmonized standards, which was briefly touched upon by Meggy and also by Kai, and it was the focus of Catherine's presentation in the first panel of today's event. And I would like to discuss this topic by doing by going through 4 points to show you why I think that the current approach of the Commission is actually in line with Regulation 1025 and therefore to disagree with the earlier speaker. And I would like to prove this point by discussing the telos of the regulation, the history of the regulation, then move to the intensity of control which the Commission is claiming to be performing with respect to the harmonized standards, and also to touch upon the scope of the control as including also the questions of inclusiveness and transparency. So the telos of the regulation. You have heard in the beginning of our event today that a teleological interpretation of Regulation 1025 would plead against a more stringent control by the Commission over the standards. And one of the arguments that was brought forward is that, in fact, the regulation, this would go against the aim of the Regulation 1025, whose aim is indeed to give effect to the new approach, and the new approach is defined also in the legal opinion as having the aim to create voluntary technical specifications. Well, I would disagree with that picture because, in fact, I think that while the telos of Regulation 1025 is to give effect to the new approach, to concretize the new approach, I think that the aim of the new approach is not to create voluntary technical specification, but to create technical specifications endowed with a very precise and specific public law effect, which is the one of the presumption of conformity. So if we look, in fact, at the telos of Regulation 1025 and we adopt a teleological interpretation of Regulation 1025, the conclusion, in my opinion, is not that the only reasonable consequence is that the Commission ought to have a limited formal role in the process, but that, in fact, because the new approach is a public-private mix of a regulatory structure with private and public elements, therefore, the Commission ought also to play a role in the process. One type of interpretation which the legal opinion did not use, while they used a more literal interpretation, a systematic, teleological interpretation, one interpretation which, in my view, has been omitted is quite an important one, which is the historical interpretation of the regulation. And I think if we adopt an historical interpretation of the regulation, there we also get to the consequence that the Commission is indeed meant to play a role in the control of the standards. And there are two elements of this historical interpretation which I think play a role. First of all, if we look at how the story unfolded before the regulation, there the standard sentence that was used with respect to the publication of the standard is that the standards were published in the official journal for information purposes only. That was the usual phrase that was deployed with respect to, say, harmonized standards deriving from giving effect to legislation, so to speak. This phrase is no longer in use, and instead the new phrasing used by the regulation is that the Commission publishes a reference when they are convinced that a harmonized standard satisfies the legislative requirements and the mandate. So I think that if we adopt an historical interpretation and we see the evolution of the legislation, you see that the aim of the regulation was indeed to endow the Commission with a much stronger control role that it had before. Similarly, if we look at how the story looked like before the regulation entered into force, this was a point that was discussed briefly before, the Commission actually could ex ante object to the entry into force of the standards. Now, that made sense because the Commission was not supposed to control the standards, so it had the power to object to the enter into force of the standards. With the regulation, the Commission does no longer have this power, and this power is only given to member states and the European Parliament, and that only makes sense if the control that the Commission exercises is no longer through objection, but through a different type of control. So if we look again at what the structure looked like before the regulation and how it changes with the entry into force of the regulation, again, this pleads, in my view, for a control role of the regulation. Now, all of this, of course, does not say anything about the intensity, of course, of this control. And I think that there are, if you wish, at least three possible ways to interpret this intensity of control. The first one would be what the legal opinion calls a detailed substantive technical assessment, Well, a sort of, if you wish, in judicial review terms, a merits review. So is the harmonized standards now the most appropriate way to comply with the legislative requirements? So that would be what the legal opinion says ought not to be allowed, because it would imply a complete redoing of what the standardization organization have done. That would be a detailed technical substantive assessment. Well, I agree that that type of deep assessment is perhaps not in place and would perhaps go beyond what is in place in the regulation, what is required by the regulation. However, that's not what the Commission claims to be doing. The Commission claims to be doing an assessment of whether the harmonized standard complies with the request and complies with the applicable legislation. So that is not, in judicial review terms, a merits review. That is a stringent legality review. And that is what the Commission is mandated to do under the regulation. Then there is also a third type of assessment that would be a merely technical, formal prima facie kind of assessment, a sort of, if you wish, unreasonableness tests in Wensbury terms. That is what the opinion claims to be the correct intensity of assessment, but I personally think that there is something in between. So a legality assessment, which is exactly what the Commission wants to be doing, checking whether the standard complies with the requests and with the applicable legislation. Finally, the opinion is also stating that it seems that the Commission, by wanting also to control whether the standardization process was inclusive and transparent and participative, is surreptitiously adding procedural requirements which are not in the regulation itself, because there is no requirement under the regulation to that end. So the Commission wanting to check that would be beyond the powers that are in the regulation. Well, at the same time, the regulation states that European standardization organizations have to encourage and facilitate an appropriate representation and effective participation of all stakeholders. Now, in legal terms, that qualifies rather as an obligation of efforts rather than an obligation of results. That doesn't mean that there is no obligation. So I think that at a minimum, the Commission is allowed to check whether the efforts have been made, which are mandated under Article 5 of the regulation. So to get now to my concluding points, and to borrow a metaphor that has been given to me by a friend and colleague who also works with standardization, I think that the new approach is a bit like driving a car. If you want to drive a car, then you need to also accept that you need to pass a test, you need to get your driving license, and you need to respect the rules that are mandated under the law for driving a car, the street code. If you are not happy with the street code, if you're not happy with the requirement of having to get a driving license to drive your car, then standardization organization can also choose different routes. They can also decide to drive a bike and not use the presumption of conformity. Thank you very much.
Thank you very much, Marialina. And then finally, we're over to, where's Bjorn? Yes, I see him on my screen now.
I'm here.
Top left-hand corner. Right, well, we're getting towards the end, so I'm sure we've left you enough time, Bjorn. Let's hear what you have to say.
Sure, I try to be as quick as I can. Great.
We have a very faithful audience.
Okay.
Most of our people are still hanging in there. So
yeah, I see 100.
No, I certainly I will not skip any points. Thank you very much for the invitation. It's always nice to talk before ETSI. Yeah, I called my presentation Legal Basis for the Commission Assessment and Review of European Standards Outside the Realms of James Elliott. I agree with former speakers that I think James Elliott is quite a narrow case. It's this one sentence that we need to boil everything on, and hopefully there will be new cases where we can perhaps know more about what are the limits to the James Elliott case and what are the limits to EU law. Let's say that. So much what I'm going to say, I think. It's a little bit educated guesswork based on James Elliott and also on other case law and what's in the doctrine and so on. Being the last, I guess I can draw a bit on what everyone else has been saying, but I think it's quite clear that the point of departure should be that compliance with harmonized essential standards or European standards confirms this presumption of conformity with the corresponding essential requirements in the EU harmonized legislation, and that when it is publicized, produce this legal consequences that you can freely circulate products which is compliant with the standard. And the question is that I was given is there a need for an implementing act for referencing these harmonized European standards in the official journal? And it's rightly stated that Article 6 does not mention, it doesn't refer to any sort of decision by the Commission or that you need to use comitology or else. It seems that it could be a rubber stamp paragraph where the Commission does a quick look, rubber stamps it, and then it's published in the official journal. What talks a little bit against that, though, is that there is a strong legal effects coming from this publication, that it seems to logically imply that there should be some kind of review after it's been processed by the European Standard Setting Organization, and where the result is fine, and where Commission can do its last ex ante control. I agree also with Maggie a little bit, even though it's not mentioned any sort of ground for making this decision in 10.6 of the Standard Setting Regulation. It could be based on either the paragraph 1 or 2 in Article 10. It could also be a combination of Article 11, where you do have certain grounds for making these decisions, and also based on Article 14 or 291 of the treaty, where we talk about implementing acts. Because in essence, the decision where to publish it and give it this legal effect is I think almost, let's say that, an implementing act. However, I mean that's I'm not certain about that, and there's certainly no case law about it which you can base that on. The question is then, if there is no need for an implementing act, or if there's no reference to an implementing act in Article 10.6, does that imply only a formal or a light review, or could the Commission do a more in-depth review? I tend to agree with Mariolina a little bit that there could be something in between just a rubber stamping it, a formal review, and a more intense state-of-the-art review all the technical experts. It depends a little bit what the requirements were when in the first implementing act, according to paragraph 1, and it could be, in my view, that the review could be more than let's say that just a formal or a light review. I also think there could be a difference between Article 10.5 and 10.6, because they do require reviews by the European Commission, and perhaps one could agree that 10.6 is just a formal review if the review was more intense under Article 10.5. We don't see that argument in the opinion, but I guess it could be added. I also want to state a little bit that logically speaking, so to say, I think if we start to lessening the breadth of review under 10.5 and 10.6 of the standard setting regulation, given what the court is saying in James Elliott and also the general underlying current, I think that standards are becoming more and more important in society, and there can be a need, or at least there's a feeling that there should be more judicial review if standards becomes more and more politically important, let's say that. What one could risk if we start to deflate what the review in 10.5 and 10.6, that there will be more review by the court under Article 263 and 267. And what is reviewed then is not the standard as such, but the status of being harmonized. That is what is going to be reviewed, and what could be invalidated on the other 263 and 267. Of course, the standard will still stand. It's still a European standard. It's just not any longer a harmonized standard. I also want to talk a little bit about an argument which is made in the opinion, which I find quite interesting, being also a competition lawyer, is that there is a reference to the procedure of creating standards in the safe harbor and the horizontal guidelines of Article 101. And it's quite an interesting take, I think, and it's quite unique on the competition law. I mean, competition law as it has been developed, focused on anti-competitive conduct, and you had to identify antitrust harm and very specifically economic, technical, legal methodology to actually identify the anti-competitive conduct that might then be in violation of Article 101. However, when you look at the safe harbor for standard setting organization in Article 101, it all deals with what kind of procedure. Is it open for everyone? Is it inclusive? Is it transparent? Do they and so forth? Which is kind of an odd requirement to have under competition law, and in my view, that would rather actually fit under the standard setting regulation. A little bit what Mariolina talked about. Under Article 4 to 6 or Article 5 of the standard setting regulation. It's a little bit odd that this is analyzed on the competition law, and there are few cases that deals with this issue. One of the odd cases that does deal with it is this ECM case, which Kai was referring to, which I think is a very interesting case. I mean, they were very unsuccessful in court. But they put forward a number of arguments when they were at the commission level. And one was the state-of-the-art argument. They stated that they had this very very developed technology for creating cement, which was far beyond any other sort of technology there were on the market, and they were then excluded by the standard that was incorporated, or that was being standardized on the harmonized European standard. And the commission, the interest of it, they did not at all address that issue of state of the art, and said, no, as long as they fulfill the safe harbor requirement, they have an open procedure, it's transparent and so forth. We're not going to dwell into the issue where the ECM was, or the EMC company was excluded or not. At least on the commission level, I think it's a quite interesting case, as Kay also noticed. I think I'm going to stop it. I'm just going to talk a little bit about the new case, which is in baking, regarding public documents or not and copyright. And I think that issue hinged partly on whether there's been a delegation of power under Article 290 TFEU. Will they show there's been a delegation? Then I guess that would imply that the standards are EU law and should be public documents that should be available, and there could not be a copyright connected to it. Of course, then you also have to answer the copyright issue. Does the standard actually fulfill the copyright protection under the national copyright laws? Yes. In the best of worlds, if I would able to say that, I think from a competition law point of view, if you take Article 101, I don't think that the procedure rules should for standard setting organizations should be judged on the competition law. It's very difficult to identify whether they're undertakings and so forth. The only time competition law should be applicable is actually if there is a cartel here under the veil of the standard setting organization. Possibly the issue about procedural issues, whether there's been good governance process, should be judged under Article 4 to 6 of the standard setting regulation, and that could then trigger invalidity claims with the Court of Justice, I think, under Article 263 and 267. When in reference to what should be analyzed under Article 10 and 11 in the standard setting regulation, I think that will reflect the requirements stipulated by the Commission. And I don't think it would be wise to have requirements from the competition that would require the best state of art, for example. I think the technology issue should be left actually to the standard setting organization and the standard setting committees. But that's my personal view. Whether Commission is legally disqualified to make such a requirement, I'm not so certain about that. I don't see the limitation in the standard setting regulation, but if that's how the standard setting tradition has been developed, perhaps you can refer to that. I stop here. Otherwise, I just continue talking for forever. I have some proposal for reading if you're interested in the next case. I wrote about copyright and harmonized standards 3 years ago. Thank you very much.
Well, thank you very much, Bjorn. That's a great contribution.